Okay. So a very good morning and welcome all of you to another exciting session where we are going to have an introduction with our speaker. So all of you must be knowing that we are organizing a series of webinars, and this is one of those webinars which we have planned to organize and give you a prospective impact on the basics of IPR. So before starting, let's welcome each one of us, all my colleagues of School of Medical Sciences, Adamus University, all our students and all the participants, and most likely our speaker today, Arvind Birajdar. So to introduce all of you, who is Arvind? Let's begin with his introduction for the first case. Mr. Arvind Birajdar is presently associated with Intellectual Property Rights Division of a reputed pharma company of Hyderabad as Executive IPR. He completed his Masters in Pharmacy in Pharmaceutics from RTM Nagpur University in the year 2019 and completed his PG Diploma in Patent Law from National Law University. He has addressed on various events of IPR in different national and international conferences or webinars. He also gathers knowledge from the various courses like Patent Cooperation Treaty from WIPO. Generally, course has been pursued by him on intellectual property rights from Geneva WIPO, IP Panorama from WIPO Academy, again from Geneva, and patent drafting for beginners from IIT Madras. His areas of expertise includes the patent prior art searching, non-infringement analysis of in-house patent, which helps to develop the final formulation by using the different strategic methods, the patent invalidation search, patentability search, patent landscape or brief IP report preparation and analysis, freedom to operate the search for various regulatory market procedures, market analysis, product selection for development, the IP status on unexpired and expired patents to formulation team, and also declaration for various countries like US, Europe, Canada, and emerging markets. The labeling query issues has also been provided by Mr. Birajdar, so that he has also played an important role as a regulatory team and also as a patent tracking and monitoring for different countries. He was associated and has been an experienced professional for IPR in the various subcontinents as well as in various other states. So today we welcome you, sir, among all others, so that you can give a very basic and brief introduction and idea to all our participants. And we look forward to hear from you about the IPR. And we know this IPR, intellectual property rights, has a very important aspect related to this kind of pharmaceutical margins, because all of us must be knowing that this intellectual property rights not only has the development of legal rights, creating the protection of various creations or inventions, but also they help in various intellectual activities in industrial, scientific, literary, or artistic fields. So your specialization, as I can notice, is about patents, copyright, marks, and trade secrets. So I would request you to please provide an inception to all the participants so that they can come closer to know and have a brief introduction about IPR. Over to you, sir.
Hello.
Yes, you are audible, sir.
Yes. Yeah. First of all, thank you so much, Priyanka ma'am, for this brief and kind introductions, and thank you so much the team of Adamus University to give this opportunity to me for sharing my knowledge with respect to that IPR. So before taking longer times, we will start the presentation directly because we already delayed sometimes.
Sure.
Okay. Just 1 minute. I will start here.
Yes, sure. Just a suggestion, Arvind, if you just can make it less than 100% visibility, then I think it will fit your screen. So it will be proper for viewing in that case.
Okay. Right now, is this brief?
It's visible, but everything is getting out of the page. So only we can see some of the portions.
Okay, something wrong with that presentation.
Right.
Sorry.
Sure.
Is this view right now?
No, Arvind, that's not visible. The screen is visible, but the presentation is not visible properly. We can just see one word that is presented by Arvind Birajdar, but
Okay, okay.
it's not clear. Can you just close your screen once and again reopen it?
Just 1 minute. Just 1 minute.
Sure.
I hope right now you have.
Yes, yes, it's clear. It's
Okay,
clear.
okay, okay.
You can start.
Just 1 minute. Okay. Okay. Uh, Before taking a time, we will start to the presentation directly because a lot of time has already wasted. Yeah. Today we are basically looking for the introductions to basic of intellectual property rights and what is the different aspects of IPR and what is the different aspect and their use in the society, use in the college or use in any level of professions. So firstly, we will discuss something went wrong with that presentation. Just 1 minute. Okay. So before going ahead, this is a presentation disclaimer. So everyone read that for a few minutes because we are actually I'm working in that department where the high level of secrecy will be maintained. So we will start the presentations. I hope everyone is audible to me. Someone from your side confirm the please.
Yes, sir. All can hear you, so you can
Okay.
proceed with the session.
Okay, sorry. Yeah, thank you. So, firstly, we will see that what is the property? Property means what? There is a two kinds of properties in the society. One is the intangible property, and second is the tangible properties. That is considered as an asset. So these are the tangible assets, which is we can everybody can see and everybody can sense that properties. So in that different kind of land is there, non-movable asset is there that will be covered in that tangible assets. But the intellectual property right is an intangible asset that will be protected from certain authorities under registrations. So this is the properties which is registered under the Transfer of Property Act 1882, sorry. Now we will see what are the different types of intellectual property rights. Intellectual property rights are basically divided into two parts. One is the industrial property and second is the copyright. In that industrial property, there is a 5 to 6 different aspect of IPR. In that, a patent is a basic and we can consider this is the heart of a property. Invention, trademark, industrial design, trade secret, geographical indications, protection of plant varieties, and these are 6 industrial properties which will be protected from protected for your invention or any in your property with respect from any higher authorities of respective authorities. So now we will see that just diagrammatically for your understanding what is the property and what property is related to the specific goods and services. In a trademark, various logos and various marks will be protected for your business value. These are the graphically presentations, so you can understand easily what is the property with respect to what kind of goods and services. These are the brain creations uh, and different aspects of properties. We will see that each and everything will be detailed. This is just a graphically picture, so for your understanding, these are the different types of properties, different types of IPR. See how in a one object or one article, all property will be covered. Like we will take one example here, like the Coca-Cola bottle is there. In that, every property will be covered in one aspect, one object that is called as a Coca-Cola bottle. Like in that the liquid syrup have the trade secret which is not disclosed anywhere till the date to the public domain. Trademark with respect to that Coca-Cola word have the trademark. Industrial design, that design should be give to that the bottle shape. And sometimes what happen in industrial design will be considered as a two types: registered designs and design of patent. In that, the design will be given to that bottle particularly, and that bottle will be get a patent. So these are the different types of properties will be covered in a one object. These are the industrial designs. Some like a fan is there. These are the geographical indications related to Tirupati Laddu comes under the geographical indication region. We will see the details in details of different types of all properties. This is just a graphical picture. Likewise, the earlier slide, here is the one mobile where all the property will be covered in a one articles, like a trade secret with respect to that confidential informations or undisclosed technology which is inbuilt into that phone will be protected by the inventor. Design with respect to that shape of the mobile. Trademark, like if it is a Apple is a phone, the backside logo of Apple will be considered as a registered trademark. Some there is a patent in the phone, like a data processing method, semiconductor circuit, or chemical compound, whatever they have used for that circuit, they all also protected by the patent. And the copyright is there, like a program is there, methodology is there, or any code is there. That all the aspect will be covered in that one articles. Now we will see different different laws with respect to that property and what are the terms of that property, and how can we get it acquired, and for what purpose they will be getting. The Copyright Act was enacted in India in 1957, and this act is specifically dealing with the original and creator works of artistic, literary, dramatic is there, or any photographer is there, any film producer is there. For that purpose, the Copyright Act was be enacted in India in 1957, and that will be exist automatically. Sometimes there is a for acquiring the copyright, you don't have any kind of special registrations. That will be comes to directly to your original work, and if you want to register it, you can register for on the basis of prima facie. For if you want to somebody has infringed your copyright, then you can file a suit against that. For that purpose, you can register that copyright into the patent office in New Delhi, and the copyright term is related to 16 years. Second is a patent. The patent will be covered under the Patent Act 1970 that was enacted in 1970 in India. That is specifically dealing with for a new invention or new creations or new ideas. For that purpose, the patent will be given, and it will protect your property for a terms of 20 years. Third is a Trademark Act, which was enacted in India in 1999. Many act was in amendment from 18th century related to trademark, but the act came into force in 2003, and this is related to your distinctive informations of your product. That product will get individualized or will get some unique identifications from other marketed already existed marketed goods. So use that will be if you want to register your trademark, that in that cases you have to register your trademark with respect to the trademark registry in India or Indian Patent Office, and this is for lifelong period of time. Every 10 years you have to get renewal of this patent. Trademark is there. Fourth is the Industrial Design Act was enacted in 2000 in India. That is specifically deals with the external appearance and any ornamentals like a jewelry, like any kind of a design, aesthetic design is there, aesthetic clearance is there, or of any article that should be protected under the industrial design. And if you want to register for that, you have to register. This is the for 15 years, and every 10 years you have to renew this industrial design. Fourth is a trade secret. This will be the laws related to that will be enacted in 1872. That is for some secrecy related to your business value or your business method. Like Coca-Cola formula have a trade secret over there. Nobody has known that what is the ingredient in that. Such kind of like KFC is there. That all kind of the foods or goods will be will get a trade secret, and that will be not disclosed into the public domain. So there is no need to registrations of that. Reasonable effort to keep a secret with respect to that your team, and this is for forever time of period. And fifth is the plant varieties. This is related to protections of plant varieties, like a farmer plant varieties and farmer right is there. This act was enacted in 2000 in India, and this is related to new plant varieties, like breeding is there, any kind of a new breeding is there, or any new plant varieties is there. So we need to registrations at this department, like Protection of Plant Varieties and Farmer Right Act. This is for 15 to 18 years. This is respect to the different to respect to that varieties. And the last one is GI protections. That is the act related to that which was enacted in 1990 in India, and this is related to for a specified good from the different territories or particular territory part, like a region or any village level. This will be covered in that level regional wise, and it will be protected for that region wise for increase your goods values or increase your product values. And that will be registrations under the GI registry, which is located at Chennai. And this act, this property, this have a timeline for forever period of times. So this is are the act which is specifically deals with what kind of goods and services will be covered, from where we can get the approval or authority, from where we can create registrations, and for what period of times, that will be covered in that slide, just for your kind of information. Next slide, we will see why IP protection is important, why IP protection is given to that particular article or particular product. See, if you have, I will give one example of one drugs, like any kind of innovative drugs should have a patent in a market. Nobody can file a generic version of that product in the market until and unless that patent expire into that particular region, or patent available in all kind of countries. So that will indirectly increase your company value with respect to your revenue and any other values of the companies. That will also help to set up your business apart from the competitors. Like in one in one innovators, once the patent has been expired, many generic has comes to the market, and it will get saturate your market and make competitions. So it will be difficult to get a higher value for your company. For that purpose, we need to protect your IP firstly. It will create a legal monopoly. Nobody has rights to file the same product until and unless expiry of your patent of respective product. Avoid infringement, like if somebody have a patent and third parties comes to the same populations to launch their product by using the same compositions of innovator, in that cases nobody can file, nobody can copy the same composition, because that will be considered as an infringement of the patent. So for that purpose, we need to protect your IP rights in the market before launching or before proceeding your product. Be sold or licensed the marketing and branding. That means anybody, if the innovator have the rights over there, then innovator can make a mutual exclusive voluntary agreement to other persons that will give the rights to third parties to productions of that particular product. In that cases, the only rights will be goes to that the innovator level. So encouraging the research and development, that is a very important aspect for the pharma educations and any kind of institution level, that will encourage the student to develop or to create a new technologies, new innovations in a laboratory level for a help of to create the solutions of on existing problems. So these are the importance of protections of IP in the market. So here one by one, we can see here one by one different properties in details. Firstly, we will deal with the patent, because that is a very important part of our level, our educations or our professions. We cannot deal other things too much high importance, because we are not specifically dealing with that aspect, but we are specifically deals with the patents in the industry, institution level, or any level of professions. So we will discuss one by one here, like a patent. So what is patent? Patent is an exclusive monopoly right which is granted by the government of India. That is nothing but of Indian Patent Office, which is comes under the government of India, or Ministry of Commerce and Minister of Commerce, sorry, and that will be granted by the government for an invention to the inventor or his assigned. If as a territorial right, like as said earlier, the patent is a territorial right. If that means if you file a patent in India only, that will not have a effect on other countries like US. Nobody, you cannot claim your rights in the US because you have not registered, you are not granted your patent in US. So patent is a territorial rights for individual countries. And for on what basis you have to get a patent, you need to disclose your all the inventions, all the method of use, method of processing of your patent to the government as well as the public domain. And the term of the patent in India or many other countries is 20 years from the date of filing of patent applications in the patent office. So these are the patent will be given to that the innovator, and what are on what basis they have to give the patent. This will be covered in that slide. We will see the next slide. What is patent? As earlier, patent is an exclusive right that is granted to the innovator to refrain or to protect others from making, using, selling, offering, or sale and import from other countries to your domestic market, that all kind of things will be refrained from other persons. For that purpose, the patent will be given to that inventor, and it will give the monetary and recognitions gains to your companies, no doubt. Why government has granted to the patent? Like in India, it has created some new IPR policy in 2016, which accelerate the patent granted and stimulate the innovator to with respect to that research and development technologies or new kind of innovations. So it will help to creations of the technologies and solve the problem which is existed in India. And the respective term is 20 years of patents. We will see that patent is not an absolute right. Absolute right. We will. There is some clause. There is some section in Indian Patent Act that will be exclude your patent to enjoy your rights. There is one case. There is a Bolar versus Roche. There is a two companies there, Bolar and Roche companies there. Bolar has used a patented technologies composition, patented technologies method for research and development purpose, for their submission purpose to the US FDA or FDA for approval of product. But they have still not have applied for the product. They have just studied on that things where the things has been already covered in that other patents, and that patent is granted to the Roche companies. So in India, there is a 107A section, subsection A and B of Indian Patent Office 1970, that will be specifically respect to that provisions. That means any persons or any act of making, constructing, using, selling or importing that patented invention in other countries or any other countries for solely use for the purpose of only research and development, that will be not considered as an infringement. This is subject to certain condition, like a government use. If the government wants to use that patented invention for in any cases of national emergency, in that cases government directly acquire that patented inventions. There is no rights to the inventor to refrain for use from using to the government. So in that cases, government can use directly without consulting or with consulting of your yourself. Importation or manufacturing by or on the behalf of the government. If government wants to import some kind of a goods, like in COVID pandemic, the remdesivir is there, remdesivir injection is there. They have to import it from the different market. Like Gilead is a company which have a patent on that. So the government has directly imported with respect to only some authorization from the respective country, respective companies. If any kind of experimental purpose, like we are a student, we are performing our practical level in a lab level. In that cases, if you want to do your experimental use, and if you want to study on that particular things which is already covered or granted in the patent, in that cases, with respect to that government permissions, we can use that one also. In the research purpose, teaching purpose, in that cases, the patent will not consider as an infringement. So the distribution of drugs or medicines by the government in dispensary, hospital, or other institution. Like as I have already said, if there is any kind of a national emergencies, in that cases, government can directly acquire and use that patented invention in the market. Like a COVID pandemic, HIV is there, like other kind of pandemic is there. In that cases, government can acquire the patented drugs and directly distribute among the peoples for a treatment purpose. So this is some exceptions to use the patented invention. We will see the next slide. What is the organization structures from where we can get a patent and from where we can apply to the respective intellectual property rights, property aspects to that different department. That will be covered by Ministry of Commerce and Industry, Department of Industry, Commerce and Promotion. This is the main ministry of, which is regulated by the central government. Under that, there is a CGPO office is there, Control General Patent and Design Office, which is located at Delhi. Among that, there is a four different authorities is there, like for patent, and design grantations. There is a 4 different offices in India, like in Kolkata, Delhi, Mumbai, and Chennai. These are the patent offices. For trademark registration, the trademark registry is there, like Mumbai, Kolkata, Delhi, Chennai, and Ahmedabad. For geographical indication registry, only there is a one registry is there in Chennai, and there is a one training center in India for the examiner or any new officer, which is located in Nagpur. This is called as RGNI PM is there. So this is a organization structures from where we can get authority for the specific your property. This is the right now we will move to the applications for patent. From where can we can make applications, who can make, and how can we make a patent applications. A true inventor or first inventor, that is the only one who create the new ideas and who create the new works, that is nothing but of an inventor. That will be that will be eligible to apply to the patent. Joint inventors, if there is a two inventor is there, sorry, in combinations, then they can also apply for the patent with respect to joint agreement. Assignee of the inventor, that is nothing but of inventor can assign their rights to that other persons. That persons is called as assignee. So the assignee of inventor and a legal representative of the deceased inventor. If there is an inventor and that unfortunately he is no more, in that cases the respective legal representative of that inventor can file a patent. These are the 4 main offices, like Delhi, Mumbai, Chennai, Kolkata. We can file the patent applications with respect to that your territorial part. That means for Mumbai region, or if you consider you are from Kolkata region, there is some district, some state is there. That state will be only respected to file a patent in the Kolkata. They persons are not filed to the patent in Mumbai, because this is they have already divided some territorial region to respect to and found found one patent office in that territory. How can we file? We can file an online mode directly through that given link below. I have shared the links. We can file it directly from there, and by post, by hand. In persons, we can also file a patent in the patent applications. So patent is a territorial right. This is not a universal patent. We can consider this is a specific country origin or region of countries. We can file a patent for the particular countries wise. So what is the different types of patents? Patent is basically 2 types. One is a product patent and second is a process patent. Product patent is nothing but of that is specifically dealing with, I will give you an example, like a tablet, a finished tablet formulations. That is the product. That is the product, and on that product we will get a patent. This is nothing but of a product that will be given to the physical article, like any kind of article which is a finished product. So the tablet, capsule, any kind of final formulations like a suppository syrup is there. So this is considered as a product, and we will get a patent on that whole product, with including of whatever the composition which is included in that. These compositions are already covered in the product, so that whole things will be covered under the product patent. So this is nothing but of a product patent. Second thing is a process patent. That is nothing but everybody has explored with that the practical things in a laboratory level. We will do the practical in a laboratory to get in a chemistry to get some compound is there. So we will use that to the process, like from the starting to end point of the process. Everything is there, like titration is there, any kind of a process is there, or any process of preparation that for the product that is covered under the process patent. That means whatever the final finished product has been done, and the process required to finish that particular product, that process will also get a patent. So nobody can use the same process for preparing the product until and unless that process will be expired, or that product or process patent will be expired, or either you should the carve out or bypassing that process or adding some other things, and you can make the same different process, not the same. If you are using that same, that will be considered as infringement. So these are the two types of patents. Next, we will see that these are the basic important aspect, basic important criteria for patentability. That means on what basis you have to get a patent. There is a 4 basic criteria to get a patent. That invention, that idea, that article, that object should have the patentable subject matter. That means that should be fall into that categories, not beyond that categories. Second aspect is a novelty, which is comes under section 21I of the Indian Patent Office. Novelty is a very important aspect to get a patent. Novelty is nothing but of we will consider as this is the original work. Nobody has filed, nobody has published, nobody has become available. The same things which you have to doing the particular research on that. That same thing will not be published in a public domain before filing your patent application date. That means if you are filing the patent application in 2000 and somebody has disclosed that same thing, same method of use, same method, same preparation process, or same invention in 1999, that will be considered as a prior art, and this is they are losing your novelty of your invention. That is considered as a novelty. So novelty is a very important part, which is, and that is considered as whatever is available in public domain before filing your patent application. That means they lose or dissolve your patent novelty, your inventions. So this is called as novelty. Second is a non-obviousness, that is nothing but of inventive state, which comes under section 21JA, sorry. Non-obviousness, that means the whatever you have doing, whatever you have inventions, that invention should be have a technically advancement and have a economically significance rather than the already existing technologies in India or anywhere. So if you file your patent for your inventions, your invention should be fall within that criteria, within that 2 criteria: technical advancement and economically significance. And that is non-obvious to the person skilled into that the same art. If the persons are working on one project, like a emulsion is there, and you are filing an emulsion, you are filing a patent for emulsions, there is no technical advancement in that. In that cases, you won't be get a patent. You lose your patent grant. I mean, you are different from patent grant because that is not fulfillment the criteria of non-obviousness and inventive state. And third most is the industrial applicability, that will comes under section 21J of Indian Patent Act. Anything which is you have to make a new things that should be have an industrial applicability. That means that will be used in industrial applications or any public applications. In that cases, if you fulfill that 4 criteria with respect to that specific things, then you can get a patent. Otherwise, if you are not fulfillment, any one thing is there, you can lose your patent from granting from the respective authorities. So this is the basic criteria for grantation of patent. This is patentable subject matter. Like any article, apparatus or machinery or its components, that will be, if the fulfillment of that earlier slide criteria, that will be get a patent. Any substance like whether a living or non-living product, pharmaceutical product, in that cases you will get a patent. I will give one example is there. Living example is nothing but of a modified, genetically modified microorganism is there, that will be get a patent if you have some recombinant technology. If you have some recombinant technologies used on that, like a source of microorganism will not be get a patent, but GMO, genetically modified microorganism, will get a patent on that. So these are the articles we get the patents. Or any composition of matter, pharmaceutical product. As I said you that for preparation of one tablet, we required some different kind of excipients like the composition. Binder is there, disintegrant is there, lubricant is there, filler is there, diluent is there. All kind of this composition will be get a patent. any process, as I said, process will get to process like to it's managed to manufacturing the final product, and that is unique to other already existed product. In that cases, the process will get a patent also. Among that, or other from that, there is some non-patentable subject matter in Indian Patent Act. Section 3 and 4 are specifically dealing with that things. The invention falling within that the scope of section 3 will not get a patent. Like in that section 3 D 3D, specifically D is there section. Part 1 and part 2 is specifically dealing. This is a very interesting, which is specifically dealing with our pharma profession. Part 1 is dealing with the mere discovery of a known form or known form of a known substances. Already there is one substance, and you have discovered a new form only. In that cases, and that form does not result have a enhancement of the known therapeutic efficacy of that substance, that will be not considered as a novel original work or novel invention, new invention, because the main discovery of known form, new form of known substance, that will not get a patent. Like a salt, ester, ether, polymorphs, isomer, particle size, until and unless they have a significant therapeutic efficacy rather than existed technologies, rather than existed product, that will not get a patent. Section 3D part 2 dealing with the specifically made discovery of any new property or new use, that is nothing but a new use of one product, new use of one medicines, will not be get a patent in India, because that is evergreening of patent laws in India. As everybody knows that India is a developing countries, or in that the patent evergreening is not considered as a new innovations and development. So the new use of aspirin for heart element, aspirin are using for the what we can say that favor is there. In that cases, we are using a heart element, that will be not considered as a new things. Our main new use of name or any aspect that will be applied for secondary indications, that will not consider as a patentable subject matter. Invention falling within the scope of section 4 of subsection 20 of Atomic Energy Act, like all kind of we don't mention the substance like uranium, barium, thorium, plutonium, that all kind of radiochemical substance will not get a patent in India. We will move towards other things. Sorry, next slide. So these are the graphically representations under what kind of aspects will not covered as a patentable subject matter with respect to that particular section. Section 3A, natural laws. Natural laws which is prejudice to the health of public, that will be not considered as a patentable subject matter. Section 3C, discovery of a scientific principle. If you are discovering any principles, scientific principles or computer programs, in that cases we will not get a patent. Section 3H is method of agriculture or horticulture. If somebody has invented the method to harvesting any kind of a any kind of a grass is there, in that cases we will not get a patent, because this is naturally evergreening of the patent laws in India. Section 3I is the surgical, curative, prophylactic and diagnostic methods, which is specifically dealing with the hospital. In that cases, we will not get a patent. Section 3J, plant and animals in whole or any part other than the genetically microorganism, that will not consider, that will not get a patent also. Atomic energy is there. Section 3K is mathematical or business method. Section 3N is a presentation of informations, like as I right now a presentation made a presentations. In that cases, if I want to file a patent, in that cases I don't get a patent. Section 3O, topography of integrated circuit, like any mobile system is there, that there is some integrated circuit is there for connections the wires to one wires to other things, other wires, that in that cases the topography or rearrangement of that things will not get a patent. And section 3P is a traditional knowledge. This is related to traditionally knowledge, like any Ayurvedic related things. This is or any traditional things is there, which is very ancient in India, that will not get a patent in India. These are excluding from getting a patent in India. we will see that one famous case studies on that section 3D part 1 and part 1 is there. Novartis versus Union of India. These are very famous case studies. Novartis is the world leading pharmaceutical company which has filed a patent application in 1997 on anti-cancer drugs like Gleevec is there, imatinib mesylate, that is used on some particular cancer. In that cases, drugs called Gleevec is a very expensive, like a cost of 90 tablet pack is around 6,70,000 rupees for 90 tablets in India, which is already in market. However, they were invented some other crystalline form, like a beta crystalline salt form of imatinib mesylate of the free base. That free base is there, and they have invented new crystalline form, and they have decided to seek a patent application over there for that beta crystalline form, because this is just slightly altered version of the Gleevec. During those days, India did not grant the product patent. That means India granted the product patent after 2005. Before 2005, because the patent amendment rule was enacted in 2005. Before 2005, there is no product patent in India. There is only process patent is there. And in that cases, the Novartis filed a patent applications in 1997, and India is not dealing with that. After the 2005, India's patent office are dealing with that patent applications, and Indian Patent Office or examiner are coming to that point that is just a mere advancement or made advancement of a new form of known substances, which is already granted a patent in other market. That will be not considered, and that will fall under section 3D. So in Madras Patent Office, earlier there was a Madras Patent Office, reviews the patent applications of the Novartis for that drug, because the case that is particularly fall into that section 3D, part 1 of the Indian Patent Act. So the Madras Patent Office has raised the questions on no major changes on known therapeutic effectiveness or it's a pre-existing form like a imatinib mesylate salt form, which is already patented in more than 35 countries worldwide. So this is the overview of the case studies. 1997, Novartis filed a patent. 2005, after 2005, Indian Patent Office reviewed that patent. And January 2006, the patent controller of Chennai was denied the grant of that patent to the Novartis. And Novartis challenged that Madras High Court judgment to the higher apex level of court. In August 2007, the Madras High Court ruled against Novartis case. In 2009, earlier there was a IPAB, Intellectual Property Appellate Board, is there. It is the final apex body of IPR. So this board has also rejected to the appeal which was made by the Novartis against of the Madras High Court. So August 2009, Novartis approached to the Supreme Court of India. Even that Supreme Court was also denied the same appeal to the Novartis, and the patent was denied to grant there, because this is fall under the section 3D, and that drugs should not have the specific therapeutically effectiveness rather than already patented technologies in other countries. Due to that, this is a very famous case studies of section 3D. We will see that what are the different types of patent application in India and other countries also. So these are the 6-7 different types of patent applications. One is a provisional patent applications. Provisional is nothing but you can file just your ideas with respect to the your inventions. There is no need to claim your inventions in the provisional applications. That provisional applications will help to prior your date for filing your complete specification, file your another patent applications. I will explain you what are the priority date. This is important with respect to that provisional applications. Provisional application can file to secure priority of invention. That means priority date, nobody can file, nobody can claim your invention after the priority date, after your provisional applications, because you have already claimed your invention in that date. So that date is nothing but of a priority date. Anybody from third parties can file a patent applications after your priority date. That will be not considered as a invention, because you have already filed your invention in that particular territory. So this is the provisional application. Non-provisional applications or ordinary applications. In that applications, you have to file all things like a claim is there, your based mode of method, on what mode of method your patent will be working, and all the details descriptions of the patent, all drawings, all claims. We will discuss that what are the part of a patent. So all these part will be disclosed in the complete specification. That is nothing but of non-provisional applications. After that completion, your patent, and you can file a complete applications for a grant of patent. Third is the convention applications. Convention applications that will comes under the Paris Convention Treaty. There is a one treaty which is helps to the innovator, which is helps to the companies to file a patent in more than 150 countries with respect to secure, with respect to claim their priority in one countries and file the same patent applications in other countries, and claim your patent application have some priority which is already claimed in other countries. Like I want to file a patent in India. Sorry, I want to file a patent in Paris. Like France is there. I need once I file the patent application in Paris through the convention application, I will then I want to file a patent application in India. I will claim the priority date of filing date of my patent applications from the date of filing in France. So that will be considered as a priority date. So this is a convention application which helps to file a patent in multiple countries by securing your priority in a particular one country. Fourth is the PCT international application. That is nothing but a patent cooperation treaty. This is basically headed by World Intellectual Property Organizations, which is located in Switzerland. The PCT application helps to the innovator or inventor to file a single applications in more than 153 countries. For example, I want to file a same patent application on a particular invention in more than 150 countries. In that cases, either I have two options. One option is there, either I have to file a PCT applications by making a single application in a single language by paying a single fee. In that cases, we have to make the PCT applications, and that applications will be applicable to more than 150 countries. And another is there, I want to file a patent in more than 150 countries. In that cases, either I have to file a single application into that single countries. So that is a very expensive thing. So for avoiding that things, we have to apply for a PCT applications. PCT national phase applications is nothing but after the filing the PCT international, that application, they have some certain time periods like 31 months. After that 31 months, that applications will goes into the national phase, and that will be treated as a national treatment for a particular patent office of their respective countries. Sixth one is a patent of addition. See, for example, I have one patent on paracetamol tablet. Now I want to add some other extra additions, like some other extra drugs. In that cases, some I have added mefenic acid is there in a paracetamol for that conditions, and I want to secure my patent on that combination. In that cases, I have to file a patent of addition because they have added someone in already existed in patent. So in that cases, we will get a patent of addition. And last one is the divisional applications. In that cases, if innovator have a two invention, one have two innovation is there, two inventor, two new ideas. That two new ideas never will be get a patent in a single patent applications. For that period, for that conditions, we have to file a different patent application. So these are the different types of patent application. This is the prior art versus invention. Prior art is nothing but whatever the available in public domain with respect to your invention before filing the patent application, before filing your intellectual property application in a patent office. Whatever the available before filing the patent application, that is nothing but of a prior art. So these are the prior art and these are the inventions. There is a certain bag is there, but there is no problem solving solutions available in that bags. Like everything is included in the invention. Like wheel is there, handstand is there, everyone is there. So that will be the problem solving, and this is considered as invention. This is considered as a prior art. Now we will see the content of patent applications. There is a one patent application, and what kind of a different contents, what kind of a different composition of that patent application. For legal information, which is comes in the first page, like a name, address, contact details, innovator, who is innovator, assignment is there, detail of foreign filing is there. That will be considered as a respective form. So that all will be covered in the front page of patent application, and other different kind of things, different kind of the composition which is covered in the patent, like technical informations, which is nothing but of specifications, like a background of inventions, what is your actual, what are the describes the need of invention, why we have to describe our invention rather than existed already technologies. This is nothing but a background of invention. Summary of invention, in that covered all the describes, embodiments, all the things. And finally is the most important part is the claims. So claim is that we can consider this is a heart of patent. Whatever I have inventions, I have claim in that claim, and that will be only protected in the patent applications. So the most important, there is a two kind of claims. One is the independent and second is the dependent claims. So these all are the just the content of patent applications. We need to fulfill all the content of the patent applications. And we have specifically dealing with respective forms and fees for filing your patent application. In that cases, we have dealing with respective form and fees while you are filing the patent application. So these are the complete specifications. I have already told you that provisional specifications and complete specifications. So in that complete specifications, this 4-5 part is covered. Title of the invention, under which field the invention is belong, that is nothing but a field of invention. Background and prior art of invention, objective of the invention, this description, like drawing is there, any kind of a drawing is there, any kind of an example is there, and finally is a claim. This all kind of a content should be covered in the patent applications while we have filing any new patent applications. So these are the content of patent applications. Now we will move towards to the process of patent filing in India. There is a basically 4 steps. One is a filing, second is publication, examination, and grant. For that period, it will require more than 4 to 5 years of timeline, so more than 10 years also, because it depends on the complexity of your patent or in invention. So these are the filing mode of the patent applications. We will see in details how to file a process in India. So file a patent in India. Once you have any kind of a concept, like any kind of idea is there or any kind of invention is there, we need to file a patent application with respect to by or using the specified form and rules, specified fee is there with the provisional patent applications. So once you file the provisional patent applications, the date of patent filing will be started from there, and after that, within the 12 months from the provisional filing, you have to file a complete specification in that cover all the content which I have already covered in the previous slide. So with completion or with complete the fulfillment of criteria of that content, we need to file a complete specifications. Here is the complete specifications within the 12 months after the provisional applications. If they are not filed, that your patent application will get abandoned. That means it rejected. If the complete specification is filed within 12 months, the publication will be made under section 11A of within the 18 months from the filing date. So once you file, then your patent will be get published into the public domain or official gazette of Indian Patent Office, and all the process will be started to review and to examine your patent applications. After publications, there is a one things, anybody can from third parties can file pre-grant oppositions of your inventions, and they claim your invention is a frivolous. They have not a novelty. They have not a they have obvious to the already available technology in the market. That in that cases anybody can file a pre-grant opposition. So once the pre-grant oppositions compilation is done by the inventor, then the examinations of the patent will be started upon the request for the examinations by the inventor after the 18 months of after the 18 months date from the filing date. in Form 18, within 48 months from the date of priority, the examination will be done here. Once the examination has been done, the first examination report has been issued from the examiner to the inventor, and they have, if any kind of objection is raised through the examiner, then the innovator should be compile all the problems, all the questions which is raised by the examiner, and that compile all the aspect or compile all the requirement, and they file a patent applications against. If again the further examination, again the further objection is raised by the examiner, the objection will be made within the 12 months from the by the inventor, and if they are not fulfilled the objection raised by the examiner, then these patent applications will be abandoned, that means rejected. And if they fulfill all the aspects, all the compilations of the objections, in that cases the patent will be granted under some sections, under 43 sections, and that will be published into the public domain after registering into the patent register, and which is available into the public domain. And within the, after there is a another hurdle is there. Once a patent is granted, there is a post grant opposition phenomena is there in Indian Patent Act. Anybody, not here is anybody, only interested persons, that is who is interested person, that is specifically dealing with the same invention, same thing, same practical, that person should be have a eligibility to file a post grant opposition after grant of your patent. In that cases, the post grant will be filed and challenge your patent applications. If they are compiled with all the aspects of the grant oppositor, then the patent will be maintained as it is. Otherwise, the patent will be rejected or abandoned. This is a process of filing a patent applications. This is overview process. The process is very complicated, but we can just understand that things, how the flow is there, what is the process, and what is the steps is involved in there. Once the objection is raised or challenged by the any third parties, the decision will be goes to the controller, and the controller have the authorities to take a decision on a final grant. If the controller reject the post grant opposition, in that cases the post grant oppositor has also have rights to appeal in the appellate board, and all the things will be depend on appellate board, and appellate board will take the decision on that whether this patent is valid or invalid. In that cases, they revoke, abandoned or rejected the patent, or either grant the patent. These are the patent application. These are the patent certificate. First front page is there. This is for India, Indian patent certificate, and this is for United States patent application certificate. It is not a certificate. This is a front page of patent application. It looks like that for your kind of information I have put over there. Another is a next type is what is a patent cooperative treaty. As I said earlier, there is another other things we can file a patent applications worldwide by filing a single patent applications which is sitting in India. If this is comes under the patent cooperation treaty that is signed in 1970 in Washington DC, United States, and that is effective from 1978. Basically, they are dealing with two languages, English and French. So the patent cooperation treaty is an international treaty which helps to and they have more than 152 contracting states, more than 152 different countries they have participated. They become a member of that treaty, and it is administered by the World Intellectual Property Organization located in Geneva. PCT make it possible to seek a patent application or patent protection for an invention simultaneously in a large number of countries by filing a single patent application internationally, instead of filing a single patent applications in a particular individual countries. So these are helps to grant your patent worldwide by filing a single patent application. So we can, if you want to file a patent in more than 10 countries, you can file a PCT applications. That will be convenient route to you to secure your invention in the secure your invention as a patent in particular countries. This is the flow chart of PCT. See, here is a month 0. We will file a patent application in your regional patent office. Like in India, have 4 patent office. We have to file a patent application in particular that country, that office. After that, within 12 months, the international application of the PCT with PCT application with PCT office is there. we can file a PCT application within 12 months from filing a regional patent office. So the timeline will be started, and the overall timeline is a 30 months period. In that cases, the all international searching, international examination, international publication, all things will be covered, all things will be scrutinized, reviewed by the respective authorities, and they will push your inventions towards to the next authorities for granting of the patent application. So once the 30 months period has been completed, your patent application will enter into that national phase. That means the whole process will be running in a PCT office only. After that, the PCT will that patent will be enter into that particular patent offices, countries patent offices. Like I want to file a patent in a 10 countries. Once the 30 months period has been expired, that patent will enter into that 10 designated countries. Automatically will be entered, and the period of patent granting prosecution has been started for that countries from their offices only. So this is just a way to file a patent application. So these are all are the patent. What are the patent? Different types of patent applications. What's the content is there? How to file a patent? What is the process is there? All things will be covered in there. Now we will see the trademark is there. The trademark which comes under the Trademark Act 1990 in India. Trademark is nothing but of a mark of that will be distinctive sign or indicator of your product, which is used by the individual or any kind of a business organizations or any legal entities, that will helps to uniquely identify the source of your product and services to the consumers. As I have already displayed, the one logos is there, Mercedes-Benz logo is there, that will be considered as a trademark. Everybody knows about that. This is the Mercedes-Benz logo, and that will be easily to understanding, easily to sense the product. That is nothing but of a Mercedes-Benz logo. For that purpose, the trademark will be given to that particular object, particular article, that will individualize your source of goods from the other competitors or from the markets. So identify and distinguish its product or services from those of the other entities. A trademark will be considered generally as a logos and any brand, any names, any articles, any words, any pattern that will be covered into the trademark. Like signature is there, name, device, label, numericals, or combination of colors also used by one undertaking or goods or services. In that case, the trademark will be given. This is the basic classifications of trademark. There is the 45 different classes of trademark, but we are not dealing with that things. We are only dealing with the class 5, which is related to the pharmaceutical industry, or everything related to trademark. Like tablet have some different kind of a shape, or there they have also get a trademark. Any kind of a packaging material, any kind of a packaging container is there, they have easiest to use to the patients. In that cases also we will get a trademark if they have the distinctive things rather than a deceptive similarities. So we will fall under the class 5. This is related to pharmaceutical class only. These all are the classes which is related to specific goods and specific services, but we are fall within the class number 5. These are the different 3 types of mark. These are indicated as like of this logo. R is a registered trademark. That means the person who have a trademark that will be registered to the trademark registry, and they have a rights to sue. They have a rights to file a case if somebody have using the same things for that the product. This is the TM is related to unregistered trademark. This is a unregistered trademark. That means the trademark is there, but that innovator has not registered the trademark in the registry. In that cases, if somebody use the same things, you cannot claim that this is belongs to you, your property. This is a service mark. This is completely different from it is a like of trademark, but have a different properties or different ornamental is there. This is a service mark, unregistered service mark. So what can be registered as a trademark? See, this is a different kind of a things will be registered as a trademark. Like word, device is there, label is there, right? Logo is there, ticket is there, any kind of a jeans pant is there, Levi's is there, they have a trademark over there. This is signature is there, name, letters, numericals, packaging and combination colors, shape of bottles, shape of containers, that kind of things will be comes under the trademark, and we can get a registration over there until and unless they have the distinct things rather than a deceptive similarities to the person. Why protect a trademark? Trademark are under not it is a bond. We can make something something different, design something different things, and that on that we have to get a pay trademark protections over there. This is not a bond by birth. You do not have to register a trademark to have it protected, but there are some advantages to the doing so. What is the advantages? Identify your product and give its name. As like everybody's know that Pepsi, these three combinations of color have a trademark, and they have easily identified to the any persons, any third persons, like any child also, everybody can easily understandable. This is a Pepsi. Also for identifying your goods in with respect to unique quality, that will helps to you for filing a trademark. So to prevent the commercial exploitations of your product, nobody has invented. See, there is one Coca-Cola. Nobody has invented the same things because they have a trademark. They have the trade secret over there. They have patent, industrial design over there. So nobody can commercial exploitations of your product. For industrial use, if any special name is there of a particular product, that product will get the trademark, and that nobody can produce the same things in the industry. So it will also helps to your company's value. That will be registered and granted for that is registered and granted for forever. But after 10 years, you have to renewal it. Any sound and smell is also get your trademark over there. Like some Doordarshan channel is there. They have some different sound to learning. That in that cases also we will get a trademark over there. Infringement of trademark. This is some example of infringement of trademark. How the market competitor can infringe your product. Infringe your product by using the similarity, deceptive similarity of that things. Like Ford is there, door is there. They have made a Ford and door. So the person coming from the market who has not have that kind of ideas related to trademark, they can easily buy the door because they are looking like a Ford and they have understanding this is a Ford. So McDonald's and Munch Burger is there. AIM ATMs, this is there. Bottle name is there. Like Coca-Cola, Coke is there. This is the deceptive similarities of the trademark, and that will helps to fool the people for purchasing the same things, which is give the same value of the original or innovator companies. So this is the infringement of trademark. Where and how to protect a trademark? This is the registry of trademark, which is located in 5 region like Delhi, Ahmedabad, Mumbai, Kolkata, Chennai office is there. You can file a trademark directly, trademark applications over there. This is the just procedure, brief procedure, trademark search. We have to file, once we have to file a trademark applications, we have to search that these things, same things will be covered in earlier anywhere or not. The application, then objection raised by if third parties, then application compilation, objection compilation, then acceptance of your applications, then journal publications. If after publications there is the same things, post publication is opposition is there, then the trademark registration. So this is just a brief process of filing a trademark. We are basically not dealing with that things too much because we are dealing with specifically in patent. So third is a copyright. What is copyright? On what basis? On what type? On what particular criteria that copyright will be provided? On whom to be provided? On for what they have been provided. So copyright is a set of exclusive right granted to the author. This is the original author or original creator who create the original work and and make it public domain. That is important. So what works are protected? That is a tangible form of expression. Your copyright form will be, should be tangible. It's not an intangible assets. Like a patent is in that intangible asset. This is a tangible form, and that is should be fixed to some other kind of articles. So it will get easily communicated with the persons with respect to that machine and devices. And must be an original work of authorship, meaning that the work must be independently created by the author as opposed to copied from other works, right? So the copyright will be provided to the artistic work, literary work is there, musical work is there, photographer work is there. Like, see, this is a copyrightable work is there, choreographic work, pictorial, graphic, sculpture work, motion picture, sound recording, right? This all things will be covered under the copyright, not in a patent. Copyright is specifically dealing with not a technical and functional things. It is dealing with the what we can say that is dealing with the only articles or object of the invention. How to create a copyright? There is no need to formal creations. Copyright, these are substitute original work fixed in any medium. Filing of copyright is, it's not a mandatory. Once you have to come your ideas brings into the market, the copyright period will be as soon as started. But need to registrations of copyright that will helps to as on prima facie to file a suit if somebody use the same things which is already you have to write over there. Which is filed in Delhi Patent Office. Sorry, Delhi office is there in copyright to protection under the Indian Copyright Act. This Copyright Act is specifically dealing enacted in 1957. What is not protected by the copyright? See, this there is a titles is there, short name is there, short phrases is there, phrases like composition is there, compounding is there. Compounding of this product that will not consider as a copyright. Any slogan which is given by the third parties that will not consider as a copyright. Ideas, procedure, methods that all will be covered in the patent, not in a copyright. So these all are not covered under the copyright protections. Next thing is their design, industrial design. Excuse me. This is specifically we have some use of this kind of a property industry also, specifically to packing your pharmaceutical product into the container. I have given a two example. There is a one Sula winery which is coming from the Nashik, Maharashtra region. That vineyard have some different kind of industrial design with respect to their bottles. So they have the rights for that bottle, which should have the distinct property, not a descriptive property. They have a distinct property. Another, I have given one example of this container, tablet packing container. There is a 4 open region over there. That open, once you have to open that region, then you can rotate your that closer and open this. This is so that will be provided for extra addition problem solving. That means they have protecting from the moisture entering into that, because they have given some additional extra other sealing layer over their closure. So that is some industrial design which helps to you for some additional value. So what is design? Design is nothing but a novel and original thing that will be given. There is a two kinds of a design, two-dimensional designs and three-dimensional structure. Two-dimensional design, which is three-dimensional design, which is specifically dealing with the shape of that design. Like any ornamental is there, any jewelry is there. In that case, the shape of that property, unique space of that property will be protected under the Industrial Design Act. And any two-dimensional structure is there that will be covered, like with respect to that any pattern of ornamental, any composition of lines of ornamentals, or any color combinations of ornamental, that will be covered in a two-dimensional structure. So that will be applied. See, the industrial design is not covered the technical and functional things of that particular article. That is dealing with the specific aesthetic and ornamental appearance of the product only. That is nothing but cover the technical and functional knowledge of that particular ornamental, particular article. So that is dealing with the only external design. Ornamental or aesthetic aspect of useful article of industry that gives the special appearance to that your product. and which differentiate your product from the market available product, and that is not covered a technical, and distribution of feature like a trademark and patent will not cover under the design. So three-dimensional, as I said, a three-dimensional and two-dimensional feature is there, that will be types of industrial design and cover the specific aspect of that property. See, there is some examples of design registration. This is a water purifier. They have some extra additions, design qualifications is there. For that, they have get the industrial design protections. Another is a motorcycle bike. The bike has some extra other covers behind that the handles, and they will create some extra addition look to the people that will be protected, that will be applicable for industrial design. Another is a brood. This is the ornamental things that will create some differentiate impact, specifically dealing with the jewelry, and some kind of a ladies garment is there that will be covered under the industrial design registration. So this is just examples of design registrations. Now we will see the what cannot be registered as a design. See, the main mechanical device, that is if somebody has come into the one container and they have just wrapping the one adhesive tapes over on the container closure, and they said my container is not leakage of any kind of a things. In that cases, the main rearrangement of a medical device or mechanical device will not get an industrial design. Any trademark not covered under industrial design, any property mark, any artistic work, prior publications, known design, scandalous or obscene matter, that kind of things will not cover under the industrial design. We will see the next things. Next slide. This is some example how the problem solving and how the aesthetically they make very good looking for a public, and how they solving the problems like and to like to the public easily, or to support to like to the public easily. So in that cases, the industry will promote their business by using such kind of a design on their ornamental or product, and they have created some additional values. See, like chair is there, they have given some example of that chair. They give the back support and the ground support also in the two cases. So that will be create some extra additional feature rather than a normal plastic chair is there. So everybody is there. They have disclosed some additional feature, and they will be get an industrial design. There is one famous case studies of industrial design, Dabur India versus Amit Jain, where that all the prosecutions which we held in the Delhi High Court in 2008. Dabur Amla hair oil. This is a bottle of Dabur Amla hair oil. They have a green colored closure is there with a rounded edge shape shape is there for that closure, and they have some other Vinayak Industries of Delhi's. They created some other bottles like Amla, and they claim that they have infringed the same rights of the Amla bottle shape. So the plastic bottle shaped with the semicircular shoulder with curvaceous back and front panel tampering into each other. So this case will be, I mean, this is very famous case, and that will be handed to the Delhi High Court. Once the all prosecutions has been done, the court has given to the judgment over there that the Amla, this Amla, Amit Jain or Vinayak Industries Amla bottle has infringed the shape of industrial design of the original Dabur Amla bottle, and the court has given the injunction granted permanently and to prohibit the Amit Jain to manufacturing such kind of a bottle and to produce or sell into the public domain. So this is just a case studies of industrial design. Next, we will see the geographical indications. What is geographical indications, and where it will be great quoted for what kind of a period, on what goods or services they will be get, or geographical indications. In India, we have a very rich storehouse of goods and services, specifically in rural areas, rural or town level areas. So GI identifies the agriculture and natural manufacturing the goods which is associated with the territorial region or locality part. So GI it comes to the specific region or territorial part which gives their product qualities to higher level and individualize their product in the market because they are producing with a very good qualities with respect to that particular territorial areas. So that GI gives protections to the group of peoples, association involved in the productions of product or using traditional skills and knowledge. Right. And whatever the GI has been GI produced, that means geographical indications protected goods has been manufactured that should be produced, processed, or prepared in that particular territorial area only, where the GI has been granted for that product. I will give us some examples in the next slide. This gives a special quality to the product due to geographical and climatic environment, reputation, specific manufacturing, farming skill, tradition, on other whatever the characteristics with respect to that product, which is attributable to the origin of region. It consists of the name of the place of origin and originate from a definite geographical territory. This is a few example like Darjeeling tea, Kanchivaram sari is there, Kolhapuri chappal is there, Tirupati laddu, Nagpur orange. That all the goods which comes to the particular territory, and if they are that goods will be produced in only that countries because the land or any kind of properties with respect to that production with respect to that productions requirement that will be produced in only that area. Like this agriculture product, Alfonso mango is there. They have a GI over there. Scotch whiskey is there. This is sprayed in a Scotland region. They have a GI over there. Handicrafts, Channapatna toys and dolls is there. Industrial product like Mysore sandal in Bengaluru, they have a manufacturing unit. They have produced the Mysore sandal, but they have coming from only the Mysore region, so they have a GI origin over there. GI protection over there. These are the notable GI in India that will individualize your product, that will individualize your market, your product quality from the other market competitor. Like Tirupati laddu will get a geographical indications. You cannot find such kind of laddu over other areas because they have some specialities. Like Solapuri chadar is there, Nagpur orange is there, Banaras sari, Mysore sandal, Darjeeling tea, Nashik grapes. This all kind of GI which comes to the particular region, and they have registered to the GI registry through the in a Chennai and will get a rights for a forever period of time. Many things is there, like a basmati is there. We have some basmati rices which is arises in the Kashmir region is there. On that also we have a GI. Many GI comes right now. The industry, the expert from the GI has very alert on that, and they want to file a GI on a particular areas. So GI right now in a very expedite manner, we can say that they have filing for a different GI to the government of India. GI can prevent the use of GI by third parties whose product does not meet the applicable standard, right? And for example, one cannot use the same things like a Darjeeling tea. Darjeeling is a tea which is produced in Darjeeling. Nobody can use the same word of Darjeeling tea, the tea which is produced in other side of Darjeeling. That will be directly infringement of that particular GI. So this helps to protect your product, your qualities, your market price value. That all kind of the things will be protected by filing a GI applications through the particular or territorial part. Now we will see the next property like plant varieties. The plant varieties that will be comes under the Protection of Plant Varieties and Farmer Right Act, which is enacted in 2001 in India. See, this is the plant varieties protections. Why protection? What criteria is there for what durations? What is the plant varieties? We will see that. Why protection is given? To provide the exclusive legal right to the breeder or whoever is the farmer breeder, which is actual original plant breeder. That breeder should get an exclusive right for that product only. So that will be registered a new varieties, and nobody can nobody can file, nobody can plantation, nobody can germinate the same varieties until and unless the expiry of that period of GI. Sorry, plant varieties. What is plant varieties? It is a plant grouping within the single botanical taxon. If somebody is grafting, like I will give an example. There is a one person from the Himachal Pradesh or Arunachal Pradesh. Uh, they have invented a new apple varieties is there. I think Harman, the name of that inventor, they have invented a new varieties of apple in Himachal Pradesh, and that apple will be germinate or plantation anywhere in India, and they can grow in anywhere in India. So for that particular persons, for example, this is suppose, for example, for that persons, the plant breeder rights will be goes to that only for that persons, because they have a created or breeder new varieties of apple. So this is the new expression of plant genes. If somebody has inserted a new genes in a plant and created some cryophylations, create some varieties by any kind of cryophyllization is there, any kind of a gene addition is there, genetically modified is there. In that cases, they will get some extra solutions over the existed plant, and we will get rights over there. So duration of the protection for trees and vines, it will get 18 years. Other crops, 15 years duration is there, protection. Extant variant is there, 15 years from the date of notifications of the variety, and that will be registered, that will be covered under the Seeds Act, Central Government Seeds Act 1966. What kind of properties the breeder have? There is three main properties, like that should be the distinct from the market things, already available plant breeders. They should have a uniformity content of all the breeders product, and it should have the stability over a longer period of time. So until unless for fulfillment of these three criteria, we will not get a plant varieties protections over there. What are the resistible and non-resistible plant varieties? This is the new varieties, extant varieties, farmers varieties, essential derived varieties that will be registered, and whatever the properties that will prejudice to the human or animal or any plant environmental health conditions or any conditions, that varieties should not be get resistible under the plant varieties. Who and where to apply? We have there is one head office in the New Delhi. Anybody who have the originator breeder, they can apply to the respective properties. Right enjoyed by the owner. What kind of right they have to produce the exclusivity? That means nobody can comes to invent, or nobody can comes to product for make product. Sorry, for plantations of the same things to sell, market, distribute, import, export, whatever the dealing method, they can be deals with their product, they can done because they have a rights over there. So this is helps to your product to increase your value in the market. There is some plants covered on the BPF Act, like Protection of Plant Varieties and Farmer Right Act. Like a fiber crop is there, like cotton is there, Betty cotton is there, jute is there. That all things will be covered under the will be protected under the this act. Next, we will see that the trade secret. Everybody knows that the trade, what is trade secret, and how it will be protected, how it will be protect to disclose other persons, what kind of a business method you have to utilize to hold it on a very secrecy level, high secrecy level. That is also important. So this is a Coca-Cola, very famous brand. We will see that Coca-Cola have the secret formula over there. Still, their formula has not been disclosed. There is a very famous formula, and the journey of formula, which is comes arises from 1886. Dr. John S. Pemberton invented a Coca-Cola. The formula was kept a close secret, shared only with a small group of that business, and not written anywhere in the document or any kind of a things. So in 1892, Asa Candler becomes the sole proprietor of Coca-Cola after purchasing the right to the business. So Asa Candler has purchasing that rights from the Dr. John, and they become the sole proprietor. In 1990, Ernest Woodcock this is another person, and a group of investors purchased this company from Candor and his family to finance the purchase, would have arranged a loan using the secret formula as a collateral. So these all formula or coming from one originator, they have hand over their rights to the second persons. The second person hand over their right to the third person. Even third person hand over the right to the fourth person. That formula, that composition of formula, process of formula, not disclosed anywhere, not written in anywhere, because that will be considered as a trade secret. So the famous trade secret is that like a formula of Coca-Cola, the Big Sack special sauce that will also not disclosed anywhere in the public domain. KFC chicken recipe, which is not disclosed anywhere, and nobody can know that what kind of a formula, what compositions they have used to prepare the KFC dry chicken is there, roasted chicken is there. And WD-40 is the formula of they have also have a trade secret. This is just examples of famous trade secrets. Examples of potential trade secret: a formula of a soft drinks like Coca-Cola is there. Survey method used by professional hostler. Any recipes is there for preparing any kind of a food. Uh, a new invention for which a patent application has not been yet filed. Right. These are all marketing strategies, manufacturing techniques, business method, computer algorithm, computer program. Right. That things will be covered under the trade secret, which is not disclosed into the public domain, and that will ultimately indirectly helps to your company to increase your value of the companies and avoid the competitor in a market. Right. Advantages of trade secret protections, as everybody knows that the unlimited durations trade secret is there. There is a trade secret for forever. There is not like a patent and copyright. Your protection is theoretically worldwide. That means this is worldwide applications. No application is required, because if you want to file applications, that means you have to file your all process. That means you have to lose your novelty or secrecy of your product. So no registration cost is there. No public disclosure or registration with the government agency also effective immediately. Right. These all are the trade secret, and this is the last one, I think. So these all are the different kinds of intellectual property rights. Basically, we will cover one by one as I cover as my good manner, because still I'm in learning phase. But basically we are focusing on the patent, because this is very important aspect. Patent and trademark, these two are very important aspect to the student or any professions, any industry, or any professions, because we are dealing with that, and we are only focusing on that two things. So we need to get more information in deeply, basically in that two things. So this is all aspect of IPR. Thank you. Thank you so much.
Thank you so much, sir, for this very brief insight about intellectual property rights. Can everyone hear me? Just wanted to confirm once.
Yes, ma'am.
Yeah. So a big thanks to our respected speaker for today's session. Now, I hope our students have benefited from this erudite talk from sir. So now I would like to take up a little bit some questions the audience may have. So some of them have already, as I can see, they have posted their questions here. So first question is from Ankita Roy. Sir, she's asking, sir, is there any IPR scope to get a patent on something which is applicable worldwide directly? What is the procedure?
Okay. That is a good question. As I already told you, if you want to file a patent applications in more than 100 countries, like you have an invention, you have some kind of ideas, you have some kind of conception. In that cases, you have to file a patent application with covering all the aspect, with covering all the content of applications. And once you have completed your filing, drafting your patent applications, you need to file a patent cooperation treaty. That is nothing but a PCT applications. There is a 2 or 3 way of filing a patent by through the PCT. One is you can file the PCT in Indian receiving office. there is a patent office in India, in New Delhi. In that patent office, there is some authorized section is there. This section is specifically dealing to receive the patent application who wants to file the same applications to the other countries. So this is receiving office. Other thing is there. There is a one investigational bureau is there. Sorry, international bureau is there. IB, which is seated in WIPO, specifically in Geneva. That IB also have receiving the same application directly without filing a patent in your receiving office, like in India. And these two things, this is two way to file a patent application. So if you want to file a patent application more than 100 countries, you have to file a single patent application in a single language by paying some prescribed fee. Through that, two options: either you can file a receiving office in India, either you can file an international bureau in a WIPO itself. So once you have to file a patent application in that, the timeline has been started, like a publication, examination, international searching, search report, everything prosecution has been started, and it will be compiled, it will be what you can say, that reported in a specified timeline period. If you are fulfilling all the criteria, then you can you will get a patent. Once it entered into that national phase, nothing but from 0 months to 30 months. This is the international phase. After 30 months, you have to, the patent application is directly automatically enter into that designated countries where we want to file a patent application. In the after entry of that national application, the national treatment has been started, and the all prosecution, all reviewing will be started into that particular national office. And if you compile all the aspects, all the compilation objection raised by that particular national office, then and then you will get a patent for that countries. And the laws specifically dealing with particular countries is different, is totally different. And with respect to that laws, we need to compile the objection raised by that particular patent office. If we compile all the objections, then you will get a patent to more than 153 countries.
Okay, thank you, sir, for answering the query. Now, I cannot find any more questions. Okay, right now, yeah. Anyone has any other question? Because in the chat box, I cannot find any questions. So anyone from the audience, do you have any questions? Anyone can unmute and just ask, sir.
Yeah, Mr. Abhirazdar, it was a nice time that I spent over here, and a lot of information I have gathered. Thank you very much for your time as well as. And just I want to have a small glimpse about the career aspect in IPR in pharmaceutical, and definitely it is not coming under this talk, as I don't want to lose the opportunity to ask an industry person, because this type of questions generally we are facing from our students. So I think you'll be somewhat better person for us, just clarify their doubts. So can you give us a small idea about their career aspects in IPR in pharmaceutical industry?
Ideas or scope, sir?
Yeah, just scope means where they can absorb and what are the things they need to do and which area they need to be concentrate on. So just a simple idea about them, because they are just budding pharmacists.
Right, sir. Right, sir.
Yeah.
That is a very important questions. Nobody has knows. I will explain it within 2 to 4 minutes. This is a very important questions, because as whenever we are in a level of master student or bachelor student, nobody from your college, nobody from our college, our classes is known about the IPR. What is the regulatory? We just know about the R&D is there. Only one thing is there, but we should be explored with that things, because until and unless have these things, the industry cannot be run, because this is the heart of industry. If you want to launch your product in any market, any worldwide market, we need to take a clear clarifications on legal aspects, whether we have a rights, whether we want to launch a product in that particular market or not. For that purpose, we need to take clarifications, declarations from the IPR department or any other legal department. until unless we have the clarification for this department, we cannot launch our product, because this is directly infringement of other rights of other persons. So this is a heart of industry, and I have requested to all the student, all the faculty members also. In 2016, India has enacted a national IPR policy. In that, the government have intentions to make awareness of the IPR in India, because we are very away from to the other developed countries, because we are just filing a 35 to 50,000, 40,000 patent applications and granted, or only 4 to 5,000 patent granted in India. But in as compared to China, Japan, as compared to all the developed market like US, they file a patent application more than 3 to 4 lakh per yearly, and granted more than 2.5 lakh per yearly. So the indirectly the innovations will help to develop our countries economically as well as socially, and that is a very important asset. And I request to all the students, be carefully create your interest to that things, because it's a very interesting things, and very we can say that this is a white collar job also. So it's a very interesting and very wide scope in coming era.
Thank you, sir. Now we would like to present our certificate of gratitude to you. So just if you just give me 1 minute so that I can share it on the screen.
Yeah, sure.
Sir,
Yeah, sir, the screen is visible.
Yes.
Yeah. So here we present our certificate of gratitude to our respected speaker. So thank you so much, sir, for this erudite talk, and hope our students have immensely benefited from the same. Okay.
Thank you so much.
Now, moving on to towards the end of the session, now I would like to call upon Dr. Raja Chakravarti, sir, to summarize the session and to extend the vote of thanks.
Thank you, Vidhasta Mandal, Ms. Vidhasta Mandal, for giving me this opportunity and present the vote of thanks for our guest, Mr. Birajdar. It was a great session that I have experienced. I could able to learn a lot of things, and definitely our students too. So at the starting, I think everybody was aware about the IPR, not in a brief aspect. So the interesting part over here is I found that you have taken an example, an interesting example like Tirupati Laddu, Coca-Cola and all, and definitely that increased the interest of the students on the topic. And briefly, you have also discussed about the copyright, patents, trademarks, GI tags, Plant Variety Protection Acts, all the things that it's quite new for us. We have heard the terms, but elaborately we gathered some knowledge about it. Definitely, a lot of things need to be learned in that aspect. But considering this is a start and building of our interest in this area, and this talk was very much important for us. There was certain laws was there. Actually, as a pharmacy person, we may not be dealing with such law in a present day. And you have aware us about different law, about the IP protections and all, details of patents, types of patents. And you have also discussed with some case studies with like Novartis as well as Dabur. So you also aware us about the PCT, that international patents, about the international patents. So all the things that we have learned from this talk is definitely the basic part of IPR. But definitely we could able to come to know what are the barriers, and certainly what are the things that is included in IPR, and definitely that will increase the interest of our students as well as our faculty members, even for me, in IPR section. So this about the I feel the summary of the today's talk, and definitely the most important part is your presence. I just really thankful for your presence in this talk, to find your time from your busy schedule. And certainly the students will be aware that why we have organized in Saturday, why not in other days, because sir is very busy in his official work, and certainly he could not able to find time during official hours and could not able to explain it properly if it was in official days. He will be having some limited time. So he requested for a day where it will be off for him so that he can take some more time to express his experience towards our students for their benefit. So thank you very much, sir, for your presence, for your busy schedule that you have bring up your time. So I'll be very much gratitude, and definitely in coming future also we'll be also having some more sessions in this aspect from your end. And the next vote of thanks definitely is goes to our platform that is provided to us by Adamas University, as well as the IT team who have organized this event in a better way in a Zoom platform. As well as I also thankful to our Dean, Dr. Sajal Kumar Jha sir, and our HOD, Dr. Sanjay Dey sir, for his support and for his confidence on us that this event can be helpful for the students as well as for the teachers. The students is the basic part of every organization, and we feel that they are the most valuable asset for us. I also thankful for all the students that you are present here to improve your knowledge, to gather the knowledge in related to IPR. And furthermore, I just want to thank all my faculty members, all my fellow colleagues for their presence, for their support, for organizing this event. Thank you very much, sir, and thank you, everyone.
Thank you so much. I really appreciate to your universities. You know that I will take 2 minutes because there is a many resources persons who are really interested to deliver such kind of a lecture. That means they are directly use the same informations to the student level. But there is a very few universities, very few colleges who are really interested to just by what we can say that to what do you say that to arrange this such kind of lecture is there. Nobody is interested. Even I was in the college time, so it's very difficult. But this is a very important information at a student level. What industry has run, what on basis they have run. We are not known about all that things in the college level, but I really appreciate about you. You have arranged such kind of lecture, and I'm really interested to deliver a lecture to the student because I always support going to that phase also. Still, I'm studying. Still, I'm studying. This is a very vast area of IPR, but it's very interesting for learning.
Yes.
Yeah.
So since I am very new in this organization, but I found whenever I have joined, immediately I found that the organization as well as the faculty members are very much deliberate to give the maximum to the students. Means in all aspects they want the students' development, and that was the best part I observed for our faculties as well as for faculties of Adamas University of our department, that we are concentrating, including me also. I also came to in this stream that we need the overall development of the students. Whenever they go out from this college, they will be having some idea, some basics, something they should know extra than that of other colleges, so that they can be fit themselves in the market with the degree of Adamas University.
That is okay. Thank you so much, everyone. Thank you. Shall I leave it?
Just a minute.
Yes, sir. We can all leave now.
Oh,
Thank you.
sure. Yeah, thank you.
Thank you.